it if it's all right for everybody. So I will first give the floor to Professor Sunkin before proceeding with introducing Backel and the speakers of today.
Well,
so Professor Sunkin, would you like to briefly introduce the Constitutional and Administrative Justice Institute, please?
thank you, Yasalt. Thank you very much. Well, welcome everybody to this workshop, conference, important session on French, contemporary French administrative law. I don't have the privilege of being a French administrative lawyer myself. I'm a public lawyer based in the United Kingdom at the University of Essex. But as Yasalt mentioned, I am a co-director of a new initiative that we've established at the University of Essex called the Essex Constitutional and Administrative Justice Initiative, or CAJI, C-A-J-I. And the purpose of the Constitutional Administrative Justice Institute is to develop expertise and research across the broad area of constitutional justice and administrative justice, both within the United Kingdom and more broadly. And we're very delighted that Yasalt is leading our comparative law aspects with her work, including her work in French administrative law and more broadly. So we're really delighted to be involved in this seminar with you, and we hope that you will be interested in developing work with CAJI at Essex. We will have a website up and running pretty soon. We will be publishing blogs, and we hope to be encouraging further sessions, both for discussion and for comparative research purposes. I don't think I need to say more about it at the moment, because I know you've got a very busy program ahead of you this afternoon. I'm going to be able to stay for some of the session, but I'm afraid I'm going to have to pop out for other events that have been unexpectedly organized this afternoon that I have to be involved in. Thank you very much, Yasalt.
Thank you very much, Maurice, for your introduction of CAJI as this new initiative at Essex. So I will also say a few words about Backel, which is the other host of this event. So Backel is an association established in 1950 with about 50 UK universities involved in Backel, with the aim of promoting the study of and teaching of comparative law in the UK. And it's very fitting that Professor Bell was for a very long time a chair of Backel. So we do, what do? We arrange comparative discussions, and this kind of event is part of what we are doing. We are also doing an annual seminar at the start of the UK SLS conference this year in Oxford in June. And we have also an annual graduate research workshop where PhD students present their work and get feedback on their research. And this year it is held in Warwick with a keynote speech on comparison in empirical and computational legal studies. So we are expanding, and we are organizing online discussions, and we also have a blog, and a number of colleagues who are on this call are contributing to this blog. We have been very kind to contribute to this blog in the past. So for various reasons, because it's an hybrid event, I will share the discussions as it's slightly easier. It's supposed to be easier to do so with students in person, and we thank the students who are here today. And we are also very much welcoming colleagues who have been joined online.
Bonjour.
So, who have joined online today from a number of jurisdictions, and also students. I think some students are joining us from Lyon and from Cambridge, for instance. So I will just very briefly introduce the speakers, and then I will leave the floor to the discussions. So I think the first speaker will be Professor Bell, and he does not need any introduction, of course. Suffice it to say that he has extensively published on matters pertaining to French legal cultures, judiciaries in Europe and European legal development, especially in relation to torts. And I think this is a topic which will come back at one point during this discussion under the guise of administrative liability. Professor Lischer is the co-author of this book, and he has abundantly published on public contract in various forms, and is now holding a chair in public contract in Lyon 3, which is nearly fitting because Essex has a partnership with Lyon 3 for the LLB in English and French law. So when it comes to the panel members, we are extremely privileged to have a balance with most distinguished experts, and I can only cherry pick a number of elements of their impressive track records, and obviously they can add if they see it fit when it comes to their turn to discuss things. So first, Professor Zommermann will come to the floor. He's from the University of Speyer in Germany, and is the editor of a triple volume on the history of administrative justice in Europe. The second speaker will be Professor Della Cananea, joining us from Italy, Bocconi, and he is the PI of the COSIAL project, European research project, which led to a number of publications in the series of the Common Core of European Administrative Law. The third speaker will be Professor Linsett, joining us from the US, and he's from the University of Connecticut, one of the editors of the Oxford Handbook of Comparative Administrative Law. The fourth speaker will be Professor Anne Jacquemet from France. She's from Clermont-Auvergne and the author of the Droit Administratif Allemand. And the last speaker will be Professor Widershoven from the Netherlands, Utrecht, who has been a Staatsraad Advocate General, so the equivalent of the Commissaire du Gouvernement in France. So I will leave the floor to you, John, for introducing the book, and then I look very much forward for the discussion in this panel.
Right, I hope I can be heard. Thank very much to Iseult for organising this, and to Maurice for the invitation to come to Essex yet again. It's an institution I've been involved coming to for at least the last 25 years. So it's a pleasure to be here. Strange that one's online and probably have more people online than in person, but that's the way of the modern world. I'm going to be very brief because, in a sense, what's important in this panel is that other people have their say, because every person's view is partial, limited, and therefore putting together different views will enable us to understand more of the overall picture. The topic of how European French law goes back, in my mind, to a conversation in May 1986 with the president of a subsection in the Conseil d'État, Rougevent-Baville, where he explained to me that they were waiting for the vice president of the Conseil d'État to retire to change the position of the Conseil d'État in relation to European law. A Gaullist was to be replaced, and that change happened in 1987, and Compagnie all'Italia and Niccolo came along in 1989. But that merely reflected a number of reforms that had come through, both with Giscard d'Estaing as president from 1974 and Mitterrand from 1981. The political climate was much more open to European influence, not least because of the ratification of the European Convention, which is Giscard d'Estaing, and a direct petition, which was with Mitterrand. And that all led to the constitutional amendment of 1992, in which formally the relationship of European law was written into the Constitution. It's part of a broader social change, because for most of you, you're far too young to remember introduction of the single market in 1992. But it made a significant difference when you no longer had to go through frontier posts. The frontier post was there, but you just drove through. When there weren't the customs declarations, and soon after the fall of the single currency, the fall of the Berlin Wall had happened, there was a spirit of change. And to some extent, the changes in French administrative law are part of a broader social movement. Now, the French loved the phrase, French administrative lawyers loved the phrase rayonnement to describe the relationship of French administrative law with other jurisdictions. French administrative law is a unique product of the 19th century and of the Conseil d'État. Unlike private law, there isn't an antecedent developed body of law on which French law built. It built itself. And there was not anything much outside France on which French administrative law could build. So it was a built up system which, as Giacinto explains, Germany and Italy then followed. But French administrative law fitted the idea that it was he was like a self-made man who worshipped his creator. You still see that in the Livre Jubilaire of 1952, which is very much focused on French questions and on French exporting of ideas. What we see with the changes in the 1980s is that that ceases to be the only direction. Europe changes things in part because legal rules change, and François' area of public procurement is one of the most radical changes, where it fundamentally changes the legal rules on which administrative actions are taken. As others will have pointed out in their papers and will point out, the European Convention on Human Rights challenged fundamental values, not simply in relation to the Commissaire du Gouvernement, now the Rapporteur Public, where French ideas of what administrative justice constitute, what was a fair procedure in court, were challenged, but also in areas like prisons and the military, where fundamental rights that had been developed by the French courts and administrative courts in the 1950s and 1960s were then taken further with a European perspective. Often what was happening was actually Europe nudging the French to develop in certain directions that some French lawyers wanted anyway. Most commonly, what you see in the journals and in the conclusion of the Commissaire du Gouvernement, Rapporteur Public, is that Europe becomes a natural reference point as part of the overall panoply of law. If you look at textbooks like Vedel and Delvolvé of 1990 and compare it with today's work, you'll see the difference. Europe features much more. And indeed, the creation of the Revue Française de Droit Administratif in 1986 was deliberately to open up French administrative law to comparative and European dimensions. But it's not just one way. The referendum of 2005, where the French public rejected the European Constitution that was being put forward, marked a moment of kind of overreach by the European Union. And the most rabid anti-European speech I've ever heard came from a French Minister of Commerce in 1996, talking about service public and how service public could not be made the object of a market. And that this was in the development of legal rules towards the Treaty of Nice. So what you've got is a sense that France wants to assert its own particularity while at the same time accepting it's part of a broader dimension, which it fundamentally upholds. Europe was not to be seen as a Procrustean bed where unity equals uniformity. Each country has its own history and its own way of doing it. So the question for this workshop is not whether Europe has become a vector of influence in French administrative law, but first, how far? And secondly, how is the equilibrium set between meeting European expectations, meeting standards within Europe, and meeting domestic sense of what is appropriate in administrative law. So I'm opening this up very much and looking forward to listening to what other colleagues have got to say in their particular papers.
So thank you very much, John, for this introduction of your book with Professor Licher. So I will suggest that Professor Zommermann makes his first comments, please.
Yeah, thank you very much, Isolde Malik. I hope you can hear me.
Yes.
Okay. Yeah, first of all, I want to thank the organizers for the invitation to the discussion on this book by John Bell and François Licher. It has been published last year. And it raises questions that are relevant, to my mind, to administrative lawyers in all countries, although it is limited, according to the title, to a contemporary French administrative law. In my short intervention, I would like to draw the attention to 4 points. First, the context of the publication. The authors know much more about that than I do, but nevertheless, I will give my impression. Second, I will ask for the epistemic aim of the book. Third, I will look at the methodological approach, and finally address select outcomes of the study if the time will let me do that. So first, to the context of the publication. More precisely, the question, why have we recently seen an increase in publications on national administrative law in an external perspective and in foreign language? Here I could make now reference to numerous collective books on topics of administrative law with contributions of authors of different countries, books that are particularly useful for comparing solutions to specific problems and questions, such as rulemaking by independent regulatory agencies or improving judicial review and so on. In our context, I want to hint at 2 books that give a deeper insight in the administrative law of another country. First, and in chronological order, the book Das Verwaltungsrecht der Vereinigten Staaten von Amerika, The Administrative Law of the United States of America, written by Eberhard Schmidt-Assmann in German and published in 2021. Second, the book Droit administratif allemand, published last year, and whose author is Anne-Jacquemet Gaucher, and we have the pleasure to hear her as one of the discussants today. And now the question, why this increasing interest in the national administrative law of another country? The American author Frank Johnson Goodnow stated in his Comparative Administrative Law of 1897 that the great problems of modern public law are almost exclusively administrative in character, and that the demand for solutions can only be adequately met on the basis of knowledge obtained, I quote, by study and by comparison of our own with foreign administrative methods. So the idea that national administrative legal orders are learning systems and have to be seen in the context of international exchange of ideas is not new. What has changed is the need for more international administrative cooperation and, in particular in Europe, for interoperable structures or settings of national administrative law. You can also say the connectivity between these systems. International treaties such as the Aarhus Convention or the Paris Agreement are driving forces of this development. Therefore, a deeper understanding not only of the specific features of national law, but on an administrative law system as a whole is a prerequisite for tackling the task of creating viable and sustainable systems of cooperation. Second, the epistemic aim of the book. The fundamental aim of the three books, the book of John Bell and François Licher, Anne-Jacques Gaucher and Eberhard Schmidt-Assmann, appears quite simple. They intend to give an introduction into the administrative law of the respective country, and this, and here it becomes already more sophisticated, for an audience not necessarily speaking the language, nor necessarily having knowledge of the administrative law of the country under consideration. Everyone who had to wrestle with translations of legal texts knows how difficult it is to find a translation that evokes the same ideas and connotations in its readers as in the readers of the original text. We can say it. It is inherently impossible, but one can try to come as near as possible to the original thinking. Writing a book on a foreign administrative law system needs more and other explanations. In all three books, there is a distinctly, or rather unspoken, further aim, in addition to the aim of providing an introduction, to give readers new insights into their own legal order at the same time. This aim is outspoken in the book of Anne-Jacques Gaucher. I quote, "Je profite du dépaysement et de l'altérité offert par le droit allemand pour livrer et soumettre quelques pistes de réflexion sur le droit administratif français." And the book provides conclusions for the French lawyer at the end of each important chapter. In the case of the book of Eberhard Schmidt-Assmann on American administrative law, the goal of gaining insight into one's own law is addressed cautiously. The author only wants to, I quote, draw on German law where it facilitates access to American law. The problems appear similar, or the chosen approaches invite for a comparison. Nevertheless, he deliberately uses analytical categories from German legal doctrine. Even if not in the latter respect, the study of John Bell and François Licher seems to go in a similar direction. Reference is made to the law of the United Kingdom, where this helps to identify clearly the specific features of French law, but also the differences and similarities. This is the case when the authors explain the conception of French administrative law against the background of the writings of Albert Van Dicey, hardly misunderstood, as the authors point out. For not few readers, it will be slightly surprised that Dicey had, I quote, admiration for the achievement of droit administratif. This is also the case when they show that it is, for reasons of data protection, in France not, I quote, possible to undertake the classic English approach of analyzing the decisions or opinions of different judges. And further, when they draw parallels between the slowness of the Conseil d'État and that of the House of Lords to recognize the supremacy of EEC law. And finally, address problems connected with public-private law divide, which is, of course, seen from a quite different perspective of both countries. Notwithstanding the similarities to the two aforementioned books, the work of John Bell and François Licher differ from both in its analytical and methodological approach. And here we come to point 3, the methodological approach. The first characteristic that has to be mentioned is the binocular perspective on the French administrative law. Binoculars do not only provide a sharper view on the object, but also improve spatial vision. What has not yet been mentioned is the explicit aim of the authors, I quote, to blend French rigor, system and principle with English attention to cases and empiricism. And this is done by two authors who both know the respective law very well, but because of the deeper socialization in one system, complete equidistance, the ideal of comparatists, can generally not be achieved by one author alone. Here, perspective, as John Bell said, have to be brought together. As far as the topics dealt with, the book covers the usual topics of French administrative law books. Roughly speaking, the regulation of administrative institutions and of administrative actions in relation to the citizens. Any other treatments would not be appropriate to the nature of an introduction to French administrative law. Nevertheless, however, some concepts are considered with less attention than in French law books. What I remarked were, for example, the concept of service public, others which far more, such as the constitutional turn, which is one of the important topics of the book. Furthermore, the book sets numerous accents of its own in its treatment of the subject matter, with special attention paid to case law. And I would say, because case law already presupposes a certain interpretation, what judgments mean, as a continental lawyer, I would say jurisprudence of the courts, is already apparent in the book's opening pages with a 40-page table of cases by date and by name. Equally, European Union cases and European Court of Human Rights cases are enumerated in the list. And here we come to a second characteristic of the book. It is the particular emphasis which is put on the impact of European law on the French administrative law. And this not as a simple fact, but as John Bell pointed out here, in its dimension and also in its chocking, let's say, with the national principles. This is of particular importance because a study in English language should also give clues for a link to European law and thus a possible connectivity to other legal orders. Against the backdrop of the changes brought about by the influence of European law, the authors can clearly show the character of the French administrative law between a slowly moving, path-dependent, and a dynamically living instrument. In this context, for example, we have to mention, for example, the Quangos Autorité Administrative Indépendante, which had a really very fast development during the last decades. At the same time, they show how traditional institutions of French administrative law, such as the Conseil d'État and the Commissaire du Gouvernement, or Rapporteur Public, can be misunderstood by European judicial bodies and are therefore sometimes subject to unjustified demands for change. Here comes up again the question of equilibrium, which John Bell mentioned in his introduction. So I come to the last point. What about the outcomes of the study? Here come, of course, numerous topics, and we will discuss some of them today. I only want to draw your attention on one point, and this point refers also to the more general question of convergence-divergence. The authors in their book recall former statement of authors, in particular Dicey and Schwarz, concerning an inductive approach of French administrative law in the elaboration of general principles. It comes even to the point to ask if French administrative law is part of a kind of common law. And this is a quite interesting point because we could ask this for several countries. In the case of France, perhaps more than the case of Germany, this would have to be discussed. But what from my mind is very interesting, that they also give figures, empirical acts that show that we might also ask, is the UK law now turning to a legalist order? This comes up when we look at the quantity of legal acts that are adopted each year. And the authors at page 30 give even concrete figures for the year 2018. It's interesting that UK Parliament passed 34 public and general acts, and the UK government 1,128 statutory instruments. In France, the Assemblée Nationale 45 laws, and at the same time for 28 ordonnances and 1,267 decrees were passed. Very similar numbers. Is this just, I would say, is it just Zufall? Is it just something which happened just in 1 year? No, we have to ask if this ideal type difference is still like we often say. Overall, we are not only before an instructive and helpful book, but also a thought-provoking study and important element for a transnational science of administrative law. This is what we all are working on. And I have to thank you personally, the authors, for this really stimulating lecture, what I could have. It was really for me full of insights. Thank you very much.
Thank you very much, Professor Zimmermann. That's really interesting also that you give illustration and links with other systems. So it sets well, I think, a discussion with for the next speakers. Thank you. We will come back to your point in the discussion, I'm sure. Professor de la Cananea, would you like to say what you want to comment upon, please?
Yes, thank you so much, Isel, for the invitation. It's great to be with you. And I'm particularly glad that I can participate in the discussion of this book, which is an excellent book, which is a book about France, but it's written with a comparative esprit. And I have to say that although French administrative law is obviously so important for other European legal cultures, including my country, Italy, there is nothing similar in our literature. So maybe we should consider a translation into Italian of the book written by John and Francois. Now, what I would like to say in the limited time that I have for my intervention is, first of all, to consider briefly what this book tells us about the relationship between public law in England and France, which is a topos, a commonplace in the positive sense in our legal literature. Secondly, I would like to come back to a point which is made throughout the book, but which John also made initially, that is to say that French administrative law is a unique product of the 19th century and of the Conseil d'État. And I would like to briefly discuss whether there is any change in this respect from the viewpoint of the role of legislation. And thirdly, I would like to consider the role of French administrative law viewed from other European legal cultures, also with regard to some more recent innovations. So first of all, as it has already been pointed out, the book opens with the relationship between England and France in the field of public law, and the authors reject convincingly the radical critique of Dicey's ideas, which has been shared by so many authors in different periods of time. So basically, their point is that he was misunderstood. And I don't think that there is much that has to be said in this respect, except that the authors tell us that French administrative law played an important role as the primary reference for conceptual ideas. This is written in the introduction. It is very important because, and I will come back to this at the end of this quick presentation, because sometimes we study the laws of other European nations because under the principle of mutual recognition, those laws can be relevant also within our own legal system. In several other cases, we study the laws, the administrative laws of other nations or of other institutions, because they can provide us with sort of order for our conceptual ideas. And probably in this book, we have much of the previous period during which the UK was part of the European Union, and still there are ties. And there is also a sort of flavor of the different period. Now, that said, let me come to the first point I wanted to make. The authors, our authors, say very clearly that even though droit administratif was largely different from the law that existed in the UK, and throughout the book, they often say this is a distinctive French product. It is a product of French administrative courts and so on. Then they add, it was, however, like the common law in which case law rather than statute has set out major principles for judicial review of administrative action, contract, and tort. I think that this is a very important starting point, which leads us to consider not only the sources of law and the importance of administrative law seen as a judge-made law, but also le fond du droit. And for example, Bell and Licher devote considerable attention to détournement des pouvoirs, and also, perhaps more importantly, to the droit en procédure contradictoire préalable, the right to be heard, the audi alteram partem. And I think that this is a point which had already been made by previous scholars. For example, in the first edition of Wade's fortunate a textbook of administrative law, he commented precisely on the case which is discussed in a detailed manner by John and Francois, that is to say the Dame Trompier-Gravier case of 1944, one of the first cases in which the theory of the general principles of law was openly used. And there are still other examples throughout the book, for example, proportionality, which was seen as foreign by French administrative judges, but thanks to the jurisprudence of European courts at the Conseil Constitutionnel, now administrative courts have been using the test based on necessity, appropriateness, and proportionality. And there is some similarity here again with how proportionality was viewed as something novel and dangerous several years ago. So one could say that despite this, notwithstanding the differences that exist in legal terminology, and also the differences which shouldn't be neglected between the idea of the rule of law and the French concept of the règne de la loi, or the German concept of the Rechtsstaat, there are important similarities. Perhaps Rivero would call them parallel developments in the standards which are imposed on public authorities. That leads me, the first comment leads me to the two questions that I would like to raise for our discussion. Now, the first is about legislation. Now, I remember, and I think that many of you will remember that some years ago, in another fortunate book, which was written by Georges Vedel and Pierre Delvolvé, they argued that if in France the civil code had been abolished, then most of French private law would simply disappear. While with regard to French administrative law, many statutes could be abolished, and French administrative law would remain substantially unchanged, precisely because it was based on the case law of the administrative judge. But the question that I want to raise is, we all agree, and the book is a wonderful testimony to the persisting importance of judge-made law, but one could nevertheless raise the issue whether the role of legislation has become more important in the last 25 or 30 years. And fortunately, part of the answer is already in the book. For example, they point out the importance of the law which was adopted in 1979 concerning the duty to give reasons, and more importantly, of the code of relations between the public and the administration. And they highlight the advantages that which are provided by the code because its norms are more detailed than general principles, for example, with regard to the audi alteram partem. So my first question would be, also in light of the other codes which are mentioned in the book, for example, the code concerning local government, all public ownership, or the medias, could we say that even though French administrative law still remains essentially judge-made law, the role of legislation has become more important than it was. My other question, which is shorter, I want to reassure Isel, who's in charge of the schedule, concerns the European dimension of French administrative law. And I have to say in this respect that the situation of other countries of Europe is largely different from the UK, because for us, during the 19th century, French administrative law was the model. And I could quote plenty, not only of treaties, but of works of judges, which clearly shows the awareness of the model which was provided by French administrative law. But my point is the following: is it still so, again, only with regard to the 19th century? For example, the débat public, which has been introduced in France at the end of the last century and which has been reinforced by the Loi Grenelle, is something which has been of importance for us in Italy, when we eventually came out with legislation in this respect. So the question that I would like to raise is whether, in the eyes of the authors, something more could be said during our discussion with regard to the European dimension of French administrative law. And that brings me to my conclusion, in which I will return to another point made initially by John about the spirit. Now, John said that the public spirit changed in 1989, and I totally agree with him. The argument could be made that if not the spirit, the tide, to use a metaphor which is well known to all of you, has changed some years ago. But still, I think that books such as these provide us with a very important infrastructure, that is to say, a bridge. Now, on my shoulders, you can see another bridge in another part of the world. And I think that that is a nice metaphor to congratulate with the authors for this wonderful book.
So thank you very much, Jacinta, for your comments and all the questions that you had regarding the relationships between case law and legislation, was the importance of case law in the past and the more challenging development that legislation represents towards the case law. So I'm sure that we will go back to that question and your other question also about the model, the French being a model maybe for other European systems in the discussions. So thank you. I will invite Professor Lynseth to join the discussion if you are happy to do so, Professor Lynseth.
Yeah, greetings, everybody. And let me join all the other panelists in thanking John and Francois for just an outstanding book, and to the British Association of Comparative Law and to Iseult especially for organizing this. She was patient with all of us, and we're deeply appreciative of that. You know, Iseult mentioned at the beginning that if we felt like we needed to add anything to our biography, that we should. And I'm going to add one little note that sort of the consistent question that I've asked for 25 or 30 years is, or the consistent concern that I've expressed as a comparative administrative lawyer, is what distinguishes the boundary of robust constitutional authority from administrative authority. So that has been my main concern. It's like, how do we draw that? You know, what are the definitions or the principles or the more particularly the kind of socio-historical phenomena that distinguishes robust constitutional authority from administrative authority? Now, the great thing about this is that this question overlaps nicely with the question of the relationship of national law to supranational law. And so I've staked out a somewhat contrarian position over the last quarter century, starting in an article in the Columbia Law Review in 1999, in which I have made the argument that the EU is not autonomously constitutional, has huge constitutional ramifications for the member states, but it is not an autonomously constitutional entity in its own right. It is best analogized to a supranational administrative agency. So that was 99. 2004, I published a piece in the Yale Law Journal in which I talked about, in essence, on the national level, the post-war constitutional settlement of administrative governance and what the relationship then of mediated legitimacy is between the administrative sphere and the constitutional sphere. In 2010, I linked those two prior projects in a book published that was entitled Power and Legitimacy, Reconciling Europe and the Nation State, in which I quite explicitly say that the EU is administrative, not constitutional. And then over the last decade, I've been toying more deeply with this distinction and what really does distinguish a robustly constitutional authority from a merely administrative one. And I've settled on, and I think it's got a lot of legs here, on the idea of the capacity to mobilize resources in a legitimate and compulsory manner. That the EU obviously has huge normative power, both in terms of rulemaking, in terms of judicial decision making, but it lacks any autonomous capacity. NGEU might affect this slightly, but not as much as people suppose. But it has no autonomous capacity to mobilize resources. So I feel confirmed with this framework in the direction of EU law. Now, the great thing about this framework is that it goes directly to the how far question. How far has French administrative law become Europeanized? And I think that there can be no doubt, and I think the book does a great job showing the influence of European law, both in terms of EU law and in terms of the European Convention of Human Rights on the evolution of French administrative law. But is that influence coming from an autonomously constitutional authority? Or does it depend? Is it mediated through the constitutional authority of the French state? And I think the answer is clearly, at least in French doctrine, that it clearly is mediated through the constitutional authority of the French state. And in that regard, the how far question is very much bound up with the other influence that John and Francois emphasize, and that is the evolution of French constitutional law as a source of positive legal norms in French public law. That I would say that there's a linkage there. So I'm actually probably going to be revising Iseult my remarks, because I'm going to be probably adding a lot of this introductory idea that I've just outlined, because what I focused in on was in some sense a dimension of the book that might seem trivial, or that the critique might seem formalistic, but it's the question of whether of supremacy versus primacy of EU law. The book consistently uses the term primacy, but it uses the term supremacy, but the actual doctrine in French administrative law and in French public law more generally is that that the national constitution is supreme, and that French law is given a primacy within the framework of the French national constitution. So that French law, European law has a specific legal character within the French constitutional regime, to which is owed extraordinary deference. But when push comes to shove, and the courts make a very serious effort to avoid push coming to shove, but if push were to come to shove, the French constitution must reign supreme over EU law. And for me, that is simply a further confirmation of the ultimately administrative character of European law, as opposed to its autonomously constitutional character. Now, the problem with supremacy as a framework is that it smacks too much of a system of constitutional federalism, and as I put it in my notes, à l'américaine. And it doesn't have to be necessarily from an American perspective, but that's a comparator that is often invoked. Supremacy implies the idea of two robustly levels of constitutional authority interacting with each other. One is state, one is federal. Now, there's a lot of sort of institutional or normative implications that flow from that. But most importantly, it implies that in cases of conflict between the two robustly, one federal, one state level of authority, that the apex court of the federal level is expected to have the ultimate competence to define the boundary between federal and state law as an extension of the constitutional supremacy of the upper level over the lower level. Now, without exactly using that language in the cases itself, that's effectively how the Court of Justice sees their own authority. Now, it's obviously a functionalist claim that they're making, that this authority of supremacy is functionally necessary to European integration, and therefore they're not precisely invoking supremacy. But we know from Internationale Handelsgesellschaft and Fotofrost, et cetera, that this is the claim that is made institutionally as a derivative of a kind of concept of supremacy. But as I say, the claim is clear in French public law. The Conseil d'État in Syndicat National de l'Industrie Pharmaceutique, says, and I'll translate, the principle of primacy cannot lead in the internal order to calling into question the supremacy of the Constitution. And then more recently, the formulation is au sommet de, that the national constitution is atop or above European law. And it, quite explicitly, if you look at the, Article 88.1, if you look at Nicolo going even further, that it is quite clear that this reservation of ultimate constitutional supremacy is made. Famously in Nicolo, which the book suggests, quote, recognize the supremacy of EU law, Friedman's conclusions famously say that, famously rejects the claim of the Court of Justice to the absolute primacy of European law over national rules. And that he referred to it as a difficult to justify logic of supranationality, which would, whatever one thinks politically, quite certainly render European law unconstitutional in France if we were to buy into this robust language of supremacy. Article 88.1 refers to the European project as constituted by states which have freely chosen to exercise some of their powers in common. And as Bruno de Witte points, stressed that this is meant to underline in French constitutional law that the EU, constitutionally speaking, is acting on behalf of the sovereign peoples of the member states, not on behalf of some European demos with its own capacity to constitutionalize the EU. With regard to legislation, with regard to the transposition of EU directives, we see both from the Conseil d'État and from the Conseil constitutionnel, this idea that that while as a matter of primacy, European law can be superior to even French legislation, that in extremis, for example, in the 2004 case about the Loi sur la confiance dans l'économie numérique, that it cannot violate in extremis principles that are inherent in French constitutional identity. And obviously that constitutional identity idea has now been incorporated into the treaties and is quite a hot area of conflict. So I would say that rather than using the term supremacy, one should first use the term primacy in a disciplined way. And secondly, that the approach that the French apex courts, in particular the Conseil d'État and the Conseil constitutionnel, use is one of strong deference, almost overwhelming deference to the choices that are made by this agent, this peculiarly important agent at the supranational level, that there's overwhelming deference both in substance and in institutional terms to the choices that are made in that process, but that deference is ultimately limited by national constitutional supremacy. So this is reflected in Arcelor, of course, that this whole way in which the Arcelor framework operates, rather than insisting directly on enforcing a national right, that the Conseil d'État looks first to see if there's an equivalent right at the EU level. That's that deferential process in action. And it is only if there is no equivalent constitutional protection in European law should the court proceed to a direct evaluation of the European norm, or as it probably more likely is embedded in a transposed either regulation or legislation, to determine whether or not it conflicts with the national constitution. That framework, which is beautifully described, I think, in the book, only makes sense within a primacy strong deference framework rather than within the confines of a supremacy framework. The Air France case, similarly, in some sense is a example of what has become to be known as inverse Arcelor, because usually under Arcelor is an individual who is challenging either a regulation or legislation as failing to protect their rights in national constitutional law. Inverse Arcelor is where the state interposes as a defense to a transposition, an incomplete transposition, that they did so because there's a national constitutional rule that requires them to be incomplete, in effect requires them to violate European law. This happened in Air France. The question there was the state's non-delegable duty to exercise its coercive power, the force publique, in the protection of rights. That had no equivalent in European law, but again, in the exercise of strong deference and in this desire to avoid a guerre des juges, but rather promote a dialogue des juges, they use their ability to analyze the facts to conclude that there was in fact no conflict. But we've seen more recently in the French data network case that is talked about in the book under the name La Quadrature du Net, and in the Bouillon case, we have a number of core state prerogatives that the state asserts in justifying a potentially incomplete transposition. One is national security. The other is the free disposition of the military. So the court is resisting. The court has its framework, its inverse Arcelor way of resisting, but it does so very indirectly through the appreciation of the facts, the analysis of the facts, and the dimensions of the law to make sure that we only have a confrontation if we absolutely have to. So in that regard, we've, as quite famously, as they did in French Data Network, they explicitly reject the ultra vires approach of the German Bundesverfassungsgericht. They're not going to go that way. I get that. There's all sorts of reasons that they invoke, that it undermines judicial dialogue in their view. It's difficult to control, and that they already have a tool at their disposal that is good enough for the purposes of resistance, which, as the Rapporteur Public said in French Data Network, at the stage of its reception into national law, to refuse to transcribe a European norm slavishly because it clashes with a substantive constitutional obstacle. This is what we call, of course, the Arcelor safeguard clause. So we have a system of indirect resistance in France. It's not the same one as in Germany, but it's important to recognize how much it shares with the German approach, right? What it shares with the German approach is that it is based on the ultimate supremacy of the national constitution and the role of the national apex courts in policing that supremacy. That is entirely shared. No, they do not approach it from an ultra vires or competence standpoint. They say flat out that they're not going to do that. But that might really be a distinction without a difference, because in terms of the ultimate question of constitutional supremacy, the supremacy is ascribed to the national constitution and not to the integration project as a whole by force of its own purported constitutional authority. So that's my general comment. My suggestion is that in future editions, that John and Francois just fix this, because the book is otherwise completely excellent. I mean, as someone who was an avocat en stage au Conseil d'État in the 90s, I mean, it brought back all the love and admiration I have for the French administrative system. I mean, and it is really just a beautiful construction. And as for rayonnement, it's certainly shined on me personally, and it deserves to continue shining on others as a consequence. And this book does a phenomenal job in doing that. So there you go.
Thank you very much for your very interesting and thought-provoking comments regarding the place of difference in explaining a number of process and dynamics within the French administrative law and its development. I'm very much looking forward to the authors will answer your point, Professor Linseth. If I may, I will ask Professor Jacquemet Gaucher to make our own comments from a French perspective, so a more intern perspective, maybe. Thank you.
Yes, I would like to thank the authors of the book and Isolde Maric for involving me in the discussion as a French academic interested in administrative law. And I especially hope that you understand my English, and it's a big reason why I send you my paper. So, first, I would like to say how useful the book is for French lawyers, because all the concepts of contemporary French administrative law are presented in English and online. And the publication of the book makes me happy too. It means that the scientific interest for French law continues abroad, even in the post-Brexit UK. Secondly, one of the main arguments of the book is that French administrative law is becoming more and more European. This external view of French law is particularly interesting, as it does not exactly to the representation that French lawyers have of their own law. In this respect, I would like to discuss the expression dialogue des juges, because the dialogue between the courts is sometimes tense, And then I would like to ask the question of the impact of the Europeanization of French administrative law. So first point, a dialogue, yes, but under tension. Two elements must be distinguished: the Europeanization of law and the discourse of the Europeanization of law. I would like to insist on the second point because, in my opinion, the authors develop an optimistic point of view in their book. As we know, the French administrative judge and principally the Conseil d'État has a very important weight in the construction of administrative law, but also as an author who comments on court decisions. Their publications are part of the organic doctrine as opposed to the academic doctrine. And the book, Contemporary French Administrative Law, mainly cits this organic doctrine when the issue of the dialogue between judges is discussed. Academic doctrine, or a part of it, has a less benevolent view of the relation between French administrative jurisdiction and the European courts. To put it plainly and with some exaggeration, I don't believe in a peaceful dialogue between the Conseil d'État and the European courts. The expression dialogue of judges is very convenient to mask differences, and I think that does not correspond exactly to the reality. It hides resistance on the part of the Conseil d'État, which does not want to lose its power over the creation of French administrative law. As long as it does not affect the autonomy of the court and its power, Europeanization is generally accepted by the Conseil d'État. But there is a sense of tension as soon as a court is likely to be hindered or challenged in its action. One example, but slowly, because Professor Rob Withers-Owen is going to talk about the French law on state liability for a breach of European Union law. Also, the Conseil d'État has communicated widely on the consequences of these regimes. They never have been implemented in practice to date. Another example, the condemnation of France by the European Court of Human Rights because of the undignified detention conditions and violation of the right to an effective remedy. Indeed, in 2008, in a case concerning a prison in Marseille, the Conseil d'État used the référé liberté. It's a remedy that allows the administrative judge to take urgent measures to put an end to an infringement of a fundamental freedom, in this case, the dignity. The European Court considered that this was an effective remedy, which was warmly welcomed by the Conseil d'État. However, France was finally condemned in 2020 by the European Court in a judgment JMB against France. The legislator intervened to try to remedy the situation by introducing a preventive remedy, which can be invoked before the judicial judge, but which remains deficient in many respects. Today, one point remains complicated for the administrative judge. He still refused to monitor the injunction he has issued against the administration. In practice, this means that the prison administration do not implement these injunctions. Detainees have the greatest difficulty to assert their rights. Litigation has therefore not yet completely dried up, and new developments are to be expected, which are future points of contention between French and European judges. Second point, what impact does Europeanization have on French administrative law? The book is part of an approach of foreign law based on the highlighting of cultural traditions and of the presentation of their history and national specificities. This perspective, long adopted by John Bell, becomes trendy for some time in France too, after a period that was devoted to the globalization of administrative law. This approach raises a series of questions. Does the Europeanization of French administrative law have an impact of the specific characteristics of this law? And what impact precisely? That was a question of how far. For example, these tensions between the Conseil d'État and the European courts underline, in my opinion, that the orientation pursued by the different courts are not the same. The Conseil d'État has an historical perspective of legicentrism. It remains a body close to the administration and still has a legal link as an advisor to the government and by drafting proposals. The European courts correspond to a different conception, perhaps closer to the German model. The promotion of the rule of law, or Rechtsstaat, and the promotion of fundamental rights, and the submission of all powers to respect for the law. In this configuration, the judge is a protector of the individual against the state and the administration. Do, for example, these differences of conception constitute a limit to the Europeanization of French administrative law? And do these differences of conception constitute a limit to the Europeanization of each national administrative law? If each national judge reinterprets in his own way, to his own logic, the European law, it would mean that several Europeanized administrative law coexist, one for each state, and not one administrative law for all the European states. But it's just a question. So I'm therefore very interested to participate in the discussion today and to hear the view of the discussants of the book. Thank you.
Thank you very much, Anne, for your points. I think it ties quite neatly in with what Jessica was saying about the law, and then with the resistance, which has also been flagged by Professor Linseth. So there is some kind of commonalities among all your points and your comments. I think that's great. Thank you very much. I will pass on to Professor Withershoven, as you just mentioned. And Professor Withershoven will focus on state liability. Professor Withershoven, would you like me to move your slides? You just mentioned it, please.
Yes, thank you, Isolde, also for the invitation to this beautiful meeting. And of course, I join all the compliments about the book of John Bell and François Licher, sorry, I missed the name. I really thought it was a beautiful book, and I've learned really a lot of it about French law, about English law, about European law. So I'm not very critical, and in fact I have some analysis and some questions, because today I have the chance to ask questions. So I will ask them, because that makes it even more clear for me. Also also for making the third edition of a book I write with, amongst others, Sacha Pregal from the Court of Justice, about Europeanization of public law. There we confront European law with national laws. And I think we can use some French literature and case law as well. So we now have this beautiful book. Okay, what I'm going to do is a bit more specific perhaps than the other introductions. I want to assess French state liability law within the equilibrium of path dependency and Europeanization. And we can go to the next slide. Now, in the book, John and Francois stated and as quote that all administrative law, also French administrative law, but also of the Netherlands, is shaped by multiple influences, and two of them I want to point out. One of them is the path dependency. It's mentioned already a few times, and according to that view, new problems and challenges in present and future in a country are handled by established approaches of the past. So this rather, perhaps a bit conservative starting point, but we have to, if you want to treat new problems, use the approaches you already had, at least insofar they were good. By the way, I didn't know the concept that good. I thought it was historical for some historians, but I have used path dependency arguments already all my life. So I'm now happy that I used a real, allowable way of thinking. That is one, path dependency. On the other hand, you have all kinds of influences, aiming at change. For instance, Europeanization, and because I'm a professor of European public law, that is, of course, an interesting dimension for me, because public law of all member states of Europe, and especially also France, is influenced by European Convention and EU law. And the question I want to pose in these 10 minutes I have is, how do these influences have shaped French state liability law, and what has prevailed? Path dependency on one hand, abbreviated by PD, or Europeanization, that is abbreviated by EUR. And in fact, I'm focusing so on the equilibrium John Bell was talking about in the introduction of this afternoon. And going now to the next slide. To have an idea about equilibrium, you first have to know what the EU influence on state liability is. Now, I don't want to go too deep in it because most people will know it, but Europe from the beginning of the 90s has influenced state liability in the member states by claiming that there is a general EU principle of EU law, where the member state is liable for loss and damages caused by to individuals as a result of breaches of EC law in the member state by administration, legislator, and the courts in last instance. So all the powers of the trias politica. And this liability exists if three conditions are met, and that are minimum conditions. The rule of law in French must have been intended to confer rights. You can read it on the slide. The breach must be sufficiently serious or even manifest in the case of courts in last instance, and there should be a direct causal link. What is already clear from the outset is that EU law does not recognize, at least not in this statement, or prescribe a principle of no fault liability, which is very important in French law. And in fact, that is true because the Court of Justice has refused to recognize this principle in the case of Fillon. And that is rather different from French law because there no fault liability exists on the principle of equality before public burdens if some conditions are met: serious harm, individual small group, and abnormal abnormal harm. So that is typical French. Europe is absent in this development. So path dependency prevails here, no influence of Europe at all. Then we go to the next slide. I have only 2 slides more, so it won't take that much. Then we talk about, then we want to compare the EU conditions for breaches of EU law and the French fault liability law, because that is more or less in the same area. Now, first, we have this typical, well, perhaps the German requirement, the rule of law in French must have been intended to confer rights on individuals. That is the first, that's the first condition for European liability. If I understand correct, French fault liability does not apply such condition. At least that is what I have read on page 1240, but I'm not very sure, not completely sure whether I'm right. Because in the recent case I referred to, the GP versus Ministre de la Transition Écologique, a French administrative court, I believe it was a court of appeal, refers a question about this condition, which is interesting. So perhaps it will exist in France. In fact, it is about the breach of air quality standards, which cause damages to all kinds of persons who become ill, etc. And they want to have the damage compensated. And the starting point is, of course, are these air quality standards prescribed by a directive? Are they intended to confer rights? Now, the court stated, no, they are not intended to confer rights because they pursue only a general objective of protecting human health and to protect the environment as a whole. And so, no, it doesn't confer individual rights. Now, perhaps I'm not want to discuss this case as such, but it is clear that that a French court did ask it. So, is this a tendency again towards Europeanization, and might it have spillover effects? That is something I want to ask from John, from the author John or Francois. And then I come to the second condition: the sufficient, serious, or manifest breach. Regarding the administration under French fault liability law, and now I quote, unlawfulness, even if it is attributable to mere error of assessment, constitutes a fault capable of giving rise to liability of public authority. Case of the Ville de Paris de Riancourt, and it is mentioned in the book. So here the EU condition of a sufficiently serious breach is not applied, and path dependency prevails in this area. Then the next slide, the judiciary because also the judiciary can cause damages by breaching EU law. Under French law, I have understand, the state is liable for a faux lourde or déni de justice caused by judicial decisions, and it has been decided by the Conseil d'État in Darmon. Now, this standard of fault, lourde, the gross fault, is also applied, as I understand correctly, in liability cases for breaches of EU law, by course in last instance. And according to both authors, this standard matches EU standard, the EU standard of manifest breach. Now, in that case, the European standard is the same as the path dependency standard, so it doesn't matter at all. The PD is Europeanization. Then coming to the legislator, French law. In French law, the state is liable for unconstitutional legislation contrary to the European Convention and contrary to EU law. Société Métropole Télévision. As I understand correctly, the latter is not explicitly based on fault liability, but on the liability of the unlawful effects of the law. And the Conseil d'État avoids using the term fault in this relation to the legislator and prefers manquement. But nevertheless, I think here, path dependency prevails, and France seems more generous than the EU standard of sufficiently serious breach. Now, then coming to the final condition, direct causal link between breach and damages sustained. In French law, state liability is limited by causation theory. Namely, damages are only compensated if they are a direct and certain consequence of a certain breach, and therefore errors in procedure or formalities cannot lead to compensation because there is no sufficient link with lawfulness. In fact, only breaches of substantive law can lead to compensation. If you compare that to European law, then the same rule applies in EU law, according to the case of Lett, Jutta Lett, very Austrian case. And here you can say that, that the French law, where it has got by past dependency, is the same as European law, and perhaps it's the other way around. European law has influenced French law has influenced European law. I think that is the case, but I'm not sure. So then coming to my final result. So now the question was, in state liability, what does prevail, past dependency or Europeanization? And I think French state liability is primarily shaped by past dependency and only to a limited extent influenced by European law. In general, French law is more generous than EU law by recognizing no fault liability and fault liability for every unlawfulness, not only sufficiently serious breaches of law. But perhaps there is a tendency to more European law because the French might be adopting the concept of conferring rights on individuals, but I'm not sure whether I'm right. So I'm looking forward to the answers of Jean and Francois. Thank you for the attention. That's the next slide. And I'm looking forward to the answers of my question. Thank you.
Thank you very much, Rob, for your presentation. You are also somehow confirming this approach of resistance, but for you it's more built on the notion of a past dependency, which is an important feature in Johnson Francois' book. I will suggest that we go to the answer from the authors. I think Professor Lichia will start, if I'm correct, answering the comment.
Yes, thanks. Isolde, could you hear me?
We do.
Okay, thanks very much. Well, thanks, Isolde, for organizing this very interesting event. And thanks also to all our distinguished colleagues to have taken this time to comment our book. I like to say the first time I'm doing this kind of exercise, and having heard everything has been said and all the fruitful comments that have been made, I must say we might have done this before the publication with the draft rather than after the publication. But having said that, I'm very interested by all the comments which have been made. Maybe I will just comment on Jacinto and Peter, and then leave John to respond to other comments. Maybe one comment also on Anne's comment I like to make. Regarding Jacinto, many thanks for all your comments. And also your paper, your draft paper that you sent us in advance. You took interesting examples of the influence of French administrative law towards other jurisdictions. I may add one other example I find interesting. You may see behind me the map of Brazil, which is interesting example of the influence of French administrative law, French civil law and administrative law, for different reasons, by the way, than the European ones, because to my knowledge, the French Napoleon troops didn't reach Rio de Janeiro, but that's another issue. Regarding as you pointed out, the question of similarities with common law, and especially the question of judge-made law, and how you mentioned the convergence between English and French administrative law, which leads to the question is basically, if I'm summarizing your first question, is French administrative law still a judge-made law? That's quite interesting. There was an article in the 80s by President Labetoul who argued that it was not the case anymore. And actually, when you look at the recent so-called grands arrêts, the one which are mentioned in the French website of the Conseil d'État, when you look at closely to these grands arrêts, you realize that they are more or less all linked with the question of the powers of the administrative courts, rather than on the substance of French administrative law. So I would say, considering this, it's probably very less a judge-made law than it used to be. Now, having said that, Of course, the example you took regarding Code des relations entre le public et l'administration, or the Code des propriétés publiques, or the Local Government Code, CGCT, some of the, or most of the provisions, at least for the first two, are actually provisions that were first issued, or rules that were first issued by the French administrative courts. And so it's not only that it's the case law that became hard law, statute law, it's also that the Conseil d'État, through its role of advisor, is very much at the origin of this statute law. So somehow it's something that is still proving the importance of the French Conseil d'État, as it still has the pen that writes most of the codes relating to the French administrative law. Now, the second question dealt with the question of the influence of the French administrative law towards other countries. I was very interested by the influence, I didn't know, of the Comité National du Débat Public that apparently influenced the Italian example. Now, of course, it's not the influence of French administrative law is very tempered now for two reasons, I guess, and I tried to develop these arguments in an article I co-wrote with Duncan Fairgrieve for the book in Libera Bicorum for Bernard Steern. The first reason, of course, is because of the now the reverse influence, and the French Conseil d'État is very much aware and open to influence from abroad, and there are examples in the case of this influence. The second point, of course, is about the importance of EU law, because, as you all know, EU law has an influence on each member state, and therefore French law has less influence because of the influence of EU law, which supersedes the influence of French administrative law. Now, I can come to my comments on Peter comments, which was very challenging. Peter, thanks. You made a lot of comment, including your paper. So thanks very much. I'd like to focus just, which is a big issue, just on the question of the difference between supremacy and primacy. Well, you're right in the sense that, in a formal point of view, the supremacy refers to the constitution in French law, and whereas primacy refers to EU law. Now, having said that, the question that you raise on the substance is the question whether what is really the supremacy source of law, the supreme source of law in French administrative law, or French public law more generally. And I would say you can consider both terms are synonymous, in the sense that, as you pointed out, for the European Court of Justice, primacy means supremacy, because it has a long-standing case law regarding the supremacy of EU law over member state law, including the question of the supremacy over constitutions of the member states. Now, that's the first point. My second point is to say basically that when you look at the substance, and you know that by heart, I know that you know, but still, when you look at French Data Network, when you look at Bouillon case, when you look at the case of the French Conseil Constitutionnel, all those cases manage to secure compatibility of French law with EU law. What you call the deference, of course, it's a deference, but I think it goes much beyond, if you read, and I know you've done, the conclusion of Alexandre Lallet on French data networks, he clearly states that le respect du droit de l'Union constitue aussi une exigence constitutionnelle, et parce que vous ne pouvez ignorer qu'elle expose la France à une action en manquement, voire à une crise politique, la mise en œuvre de la clause de sauvegarde constitutionnelle ne peut être qu'exceptionnelle. It's basically the idea that everything must be done to avoid any risk of incompatibility with EU law. And it goes on, and in the conclusion of Mireille Lecor, she explains how far we can go to make sure that French law is compatible with EU law. I'm just taking the one more example than the one you took in your paper, Peter, which is the decision from the Conseil constitutionnel of the 28th of January 2022, which, by the way, regards exclusion grounds for public procurement and concession contracts. I'm not only interested in this kind of administrative law, but still, this one is quite a good example where the French Conseil constitutionnel said automatic exclusion for reason of conviction of candidates is not a criminal sanction, which is very debatable because there can be also exclusion decided by a court, not automatically. And so when it's decided by a court, it's a criminal sanction. When it's not decided by a court, when it's automatic, it's not a criminal sanction. So it's very debatable. So everything was done in this case to make sure French law was compatible with EU law. Now, to finish on this question of supremacy, I'd like also you to consider the number of cases involved, involving a potential conflict between French constitutional law and EU law. For the French Conseil d'État, we have like 3 or 4 cases since Arcelor. From the Conseil constitutionnel, quite the same, 4 cases. So it's pretty rare that there's a risk of incompatibility. It doesn't mean that it's not important, as a famous French comedian put ironically about the death penalty. What's the fuss about the death penalty when you realize that it concerns like 1 or 2 people per year in France? So of course it was ironic, but meaning that it's a question of principle. But still, in practice, EU law is imposing its supremacy over French law through the directive and regulations. So in terms of numbers, also this kind of supremacy in practice. But I do reckon we should clarify this point on maybe a second edition or on some point online. And just to finish, to leave the floor to John, one remark from Anne comments among many of the comments she made. I do agree with her regarding the question of dialogue between judges. I was about to say the concept of dialogue, on which I've been working on since 2003, where we organized a conference on this topic in the city of Metz. It's basically an attempt, to my view, an attempt from the Conseil d'État and other member state high courts to try to influence the case law of the Court of Justice of the European Union. And I do agree that sometimes it's much more like a dialogue de sourds rather than a real dialogue. And by the way, the event we are organizing with John Bell and Anton Fairgrave, with meeting between judges, both at national and European level, we are having difficulties to find judges from the European Court of Justice, whereas the European Court of Strasbourg always take part in this kind of informal meetings. So that's one example of the lack of dialogue to a certain extent. Thank you for your attention, and I'm pleased to discuss a bit further, but I like first to leave the floor to John.
Thank you very much for your clarification and the points you just made about the speakers, the comments of the speakers. I will give the floor to John for some comments, reflections.
Well, I mean, the first thing is that the commentators are very helpful. Inevitably, our perspective is only one perspective, and the contribution that they make is very helpful to clarify and sharpen up certain issues. And in many ways, I mean, I think Karl-Peter's presentation in terms of their methodology is actually very helpful, because it's an ongoing process. You can only write a certain amount, and what you leave out is as much as important as what you leave in. So on the one hand, what we've done is to present aspects of French administrative law, but it is very much the general administrative law as opposed to the special. Now, and normally, if you look in any textbook on French contract law, that you will have a section on general principles and another section on special contracts, which usually contradict it. And there's a lot of that if we look at the major bits of French administrative law, which are things like immigration, social security, the things that are of daily operational importance to ordinary people. So what we've been trying to do is to tease out some of the general principles, the general and slightly distant overview. I think Karl-Peter's got a very important point, therefore, about how far administrative law is legislative and how much of it is case law. It is very clear that in the special part, it is overwhelmingly case law. And the important thing about case law is that case law is looking a bit backward. Whereas if you are going to introduce change and radical change, then you do it in a systematic way through legislation. And the number of things that various people have picked up in terms of changes in the procedure of the administration have really required legislation. Case law was not good enough as a tool to change the structure of the administration and the way the administration behaved. And that's true to surprisingly lesser extent in England, that an awful lot has been attempted by codes of practice in England. A lot of its development by soft law, and perhaps what we might have focused on a bit is the third element, not only case law and hard legislation, but also the role of soft law in governing the administration. And I think it's there that institutions like the Mediateur in its previous incarnation, the Défenseur des droits is actually a very important institution that has a parallel role to the role of the Conseil d'État. So the judges don't have the field to themselves. So I think what is rightly pointed out is that if legislation is an important tool of change, an increasingly important tool of change, then the courts play a second role. And then we go back to Francois' point about the importance of the Conseil d'État in shaping the legislation rather than the Conseil d'État in judging the acts of the administration once it's finished. So I'll leave it at that. But I mean, there's some very important points in that. The sort of second point that I might move on to in Anne's paper is a good question about how far there is resistance, and she's perfectly right that inevitably the picture is seen differently by French judges compared with European judges who have a different agenda. As she pointed out, the agenda of the Strasbourg court is got a different path dependency to the French administrative courts. It is, on the one hand, seeing things very much from a 1945, 40, 50 perspective, but then changed by the way in which the 1989 fall of the Berlin Wall has reconceptualized the importance that many of you have been pointing out in the rule of law, and rule of law in a particular dimension. So Peter's point about reference to the American model is actually partly shaped by the fact that many of the judges of the European Court of Human Rights were influenced by American and Canadian lawyers in that very important period between 1990 and 1995. That what we see increasingly as the model coming through very much from the Strasbourg court, it has deviated the path dependency in a particular way, and I think that's actually quite important. But one of the things that I think Anne's pointed to, and particularly in the prisoner's case, because I think that's a series of prisoners' cases, because what she's rightly pointing to is the failure of French administration to comply with the judgments of the French courts, and not just the European. What you've got, I think, in those very interesting cases which she points to, is the French administrative courts trying to say, well, okay, yes, there's an ideal in the European legislation, but we've got to deal practically with what the administration can cope with. What's the pace of change that the administration can deal with? And she's quite right that there are criticisms by doctrinal writers, relatively recent articles in the Revue Française de Droit Administratif, criticizing the decisions of the French courts by reference to the European court, because they are too tolerant of the slow pace of change by the administration. And I think that position of the French administrative courts, as she pointed out, as close to the administration and therefore more tolerant of refusal to comply, is something that I think that needs calling out. And I think that's where what she's pointing to is that there are differences between how a French administrative judge looks at the problems which are on the ground and how courts in Luxembourg and Strasbourg pontificate at great distance without understanding how it works. She also asks whether European law has influence on the characteristics of the way the law operates. and whether the European courts are much closer to the German model. I think that probably is right. And I think, but I'm not sure it's necessarily the German model. I think it's also the American model because of that. Who taught the administrative judges, particularly European constitutional administrative judges between 1990 and 97, because I think they shaped the characteristic of how Bulgaria, Poland, Hungary, and therefore those are the people that are appointing judges to particularly to the Strasbourg court, but to some extent to the Luxembourg court, are coming at it from a very different perspective, and it's not necessarily Western European. So it's interesting how those work. And Rob Vidarsor often is asking very practical questions about, okay, where does it make a difference? He's right, absolutely, that the French administrative law doesn't start liability from the perspective of the Europeans, nor does it in fact start from the basis of French civil law either. It starts from the development of law in the communes from the 18th century. It's one of the few bits that continues from the 18th century. And it's developed distinctive principles because of how you handle problems like the fault of the legislature, because much of that is to do with expropriation and how expropriation is seen by the Constitutional Council as well as by the civil law courts. So to some extent, it's answering different questions from the European courts. What I think the Strasbourg court has done for the French, as it's done for the British, is to emphasize that immunities must go. I think you'd look at the area of what areas were, even as late as the 80s, prisons, schools, and other military, how far they were immune from suit and how far that's been abolished under the influence of the Strasbourg court. And European Union liability law, I think you're right, is one where the European Union doesn't really like to award damages because it actually hasn't got the mechanisms for dealing with the factual questions. And so to a great extent, there's not as much spillover. That if we look at the kinds of immunity, you're right, the judiciary is one of the few areas left where faute lourde applies. Almost everywhere else doesn't apply. And what we see, I think, is French law, as you say, operating on its own and only providing parallelism where it feels it needs to. And the point you're making about the environmental case, which is still very much ongoing in France, not least the injunction point, the question of liability for legislative default is one where what we would have to say is that French law does not start from the German perspective of requiring fault to be equated to the breach of an individual right, but it's the concept of harm that would make a difference. That, in a sense, unless you can prove that you suffered harm as a result, you can't claim damages. And so it's although fault is simply breach of the norm, you've then got a concept of harm, which then acts as the controlling principle. And that's the same kind of problem that you see in French private law, where concepts like fault, harm, and causation are used differently as control devices from where they're used in German or in English law. You need to look at the package of those three devices and say, well, are we getting to the same result by different concepts? And I think you're probably right that there's a much closer proximity than appears on the surface, because of the way in which concepts like harm and causation are used as control devices, both in French public and French private law, rather than the German approach, which is both in public law and private law, to use rights or protected interests as the basis of liability under 823 BGB, as well as 839. So interesting questions, not giving complete answers, but I think what I would say is you've stimulated a lot of very interesting points of where French administrative law is trying to reposition itself in the areas that you pointed to.
So thank you very much for all these discussions and these exchanges. I'm aware that we are nearing the 2 hours of the discussions, but I definitively would like to give the floor maybe to some questions, or some either from the panel, if you have some reaction to what Francois and John have said, or maybe from what other colleagues have said on the panel, or also to other members of the audience, if there are some people having some questions or wanting to raise their virtual hands, please do so. Otherwise, I will just ask a little question while maybe people think about one or the other questions, but something that we did not discuss at all, or not directly, at least today, is the question of sovereignty. And some of you mentioned the idea of source of law, which may be connected in some ways to the idea of sovereignty, and of course, supremacy are connected to sovereignty. But we did not mention, I did not hear at least the notion of sovereignty, and I was wondering if it's just because you don't think it's relevant in thinking about the Europeanization of French administrative law, or whether or where you would put your book and what you have discussed in the book in relation to the concept of sovereignty. I mean, internal sovereignty and maybe external sovereignty. If you have some thoughts about that, either.
Yeah.
Or
Maybe one point, and I've just seen that Peter maybe wants to comment as well. Well, personally, I would say the question of sovereignty is, of course, important. But when you look at the reception of the Arcelor case and the equivalent from the Conseil constitutionnel, it raised political questions and debates because of the question of sovereignty. Of the French sovereignty, so internal sovereignty, as you put it. So, and so I would say sovereignty is the political translation of the debate about supremacy, as we just had with Peter. It does not directly appear as such, as you know. The French Conseil constitutionnel speaks about principe inhérent à l'identité constitutionnelle, which is not directly a reference to sovereignty. Of course, you may say, well, it's more or less that, But once again, we have very few examples of this identité example constitutionnel, plus the few examples we have, the Conseil constitutionnel or the Conseil d'État regarding the absence of equivalent at EU level, managed to secure, sometimes quite surprisingly, to secure a compatibility with EU law. So of course it is underlined by this question of balance between these principes inhérents à l'identité constitutionnelle and the EU law, but it's not explicitly said as such. But maybe Peter wants to comment on this or something else.
Please do come in, Peter.
No, I would probably, I think I would endorse that almost entirely. I agree with Francois that what we're, the use of the word sovereignty is sort of it shifts us slightly out of the legal domain into the political one. I've had this idea, this notion of as if constitutionalism, and I think that some people respond, well, you're not really talking about constitutionalism, you're talking about sovereignty, because when we get into the area of legitimate and compulsory mobilization of resources, human and fiscal, then we really are talking about sovereignty in some sense. And I tend theoretically to equate the two. I would say with regard to Francois and what you just said, and also what you said in your principal response about the effort to secure compatibility, I totally agree with you. I think that there's a huge effort on the part of the apex courts, both the Conseil d'État and the Conseil constitutionnel, and I don't study the Cour de Cassation, so I can't speak to that. I guess my point is, even if you're going to maintain the argument of that formally speaking, there's a distinction, but that substantively they're synonymous, which is what you said, the compatibility exercise is really only comprehensible within a primacy framework rather than a supremacy framework, unless one is going to say, well, we have an alternative conception of supremacy in the EU and it's not American, and that's also fair. I also think a fair counterpoint to my point is the mere fact that France did adopt, say, Article 88.1 and does see this exigence constitutionnelle that you described, Lallet and Le Cour, emphasizing, I could be accused of being formalist there and say, listen, the very fact that the French Constitution was changed because it was a recognition on the part of the constituent power at the national level that unless we wanted to leave the EU, we had to do this. And so that's the counter argument, that it really is, it's not merely functional, that it really is constitutional in some way. But I agree with you, in the context of this book, you don't want to go down that rabbit hole. But I do think, and I think you agree that maybe tweaking how you present supremacy and primacy, I'm only talking about refining, a total of like 4 or 5 pages in the book. I mean, the rest of it, as far as I'm concerned, is great. And the bottom line is that it cannot be denied the European influence on EU law in the same way that the constitutional influence can't be denied. And I think that they overlap. And so I think in the end, we both agree, right? But I'm a stickler for this distinction because I have certain kind of, I think, empirical, but also, or descriptive, but also normative commitments that are almost certainly different at the margin than maybe yours, or what you see as the center of gravity of your French publiciste with regard to this relationship.
Yes, thank you very much for this supplement in the discussion. Are there any other questions? Professor Zimmermann, please do go ahead.
Yeah, I know that time is over, but I wanted to come back a bit on the general principles and the question, case law on the one hand, legislation on the other one. I think in Europe we have quite different currents in this point. When we look at the development of administrative law in the 19th century, we had in the beginning very spread over specific rules. And what happened then was that judicial bodies, or also the doctrine, started to elaborate the underlying principle of these rules. No? So they could, this is an induction. I hope it's the right English term. It's inducive in induction. This was the way. And I think this happens in all legal orders like that if you do not have general rules. So historically speaking, it's a special stage of developing principles. Later, the courts became more active, developing out of existing general principles, other principle, concretizing perhaps the main principle like fairness or other. What we can observe, I think, already in the 20th century, at least in some countries, above all in the second half of the 20th century, that these principles are derived from positive law. In many countries, the constitutional provisions are the source for these principles. That means that conceptually or methodologically, the courts interpret the Constitution. They do not make law, they interpret the Constitution. In some constitutions, we have already laid down quite a lot of general principles that are applicable for the public administration. And in other cases, we have some general principles in the Constitution, and from that starts the concretization. I think it's not only the case in Germany, where, of course, after the Second World War, we tried to, after the catastrophe, we tried to build up an existing and well-assured system. But also, if you look at the European Union, the principles, the general principles started also by inducing it from the national orders by comparison, which did the European Court of Justice. And the result of the comparison were general principles. But we also see here a tendency to codify it, not only in the European Charter of Human Rights, but also in certain secondary instruments and in the primary law in general, if you look through the treaties. So what I want to say is that normally the direction goes more in direction legislation. If we put it in a large sense, legislation, including constitutions. And in France, we have this very interesting situation that general principles may have constitutional value, but they may also have the value of simple the ranking like the ordinary legislation. This is still a quite sophisticated point, but if I look at many countries, also Spain, for example, the deduction, this is more a deducive approach now, coming from constitutional principles, and methodologically speaking, it's a kind of interpretation.
Yes, thank you very much for your comment about the cycle of changes in the interaction between courts and legislation in that regard. I don't know if there are any other questions or comments. Yes, Professor Della Canania, you have a comment.
Thank you. So, just a very quick comment. I very much agree with the answer that both Francois and John gave to my question concerning legislation. And interestingly, that shows that while for a long period of time, the role of the Council of State was to promote change gradually by way of judicial decisions, slowly evolving. Now it plays a role within the legislative process, and the Code de Relazioni is a wonderful example. That would imply that one of the initial features of the French system, that is to say, the centrality of the Conseil d'État, is unchanged, even though the ways through which the Council of State exerts its role are different. And that is an extraordinary example of institutional adaptation.
Yeah, it's a very good point. I think people have mentioned, my colleagues have mentioned resistance in some ways, and you mentioned another way of,
I'm
transformation.
Italian. I tend to look at things in a slightly different manner.
No, it's an interesting addition, I think, to the picture that we have been building across these different presentations. I'm very conscious about the time, and I'm very sorry to interrupt this discussion because there are probably a few other points that we could make. But as some of you may know, the presentations and the main presentations will be published on a blog online. So please do go back to these presentations. If you have comments or reactions, I suppose you can also go back to John and Francois, or even the author of the comments to keep the discussion going on. And thank you so much for your time and all the efforts you have made to make it a very good discussion. Thank you very much.
Thank you.
Thank you.
Thank you. Goodbye.
Thank you. Bye.
Is it okay?
Yes.